about criminal liability, and that could be criminal. I'm going to give you practical advice, and I do look forward to getting questions. And yes, I am a veteran, and I want to thank all of you out there who are veterans or who have family members. The veterans are the future of our country, and if you see them in the airport, thank them for their service. Maybe offer them a cup of coffee. That's the way it ought to be. As we go through this PowerPoint, I'm not going to read it to you. It's just a prompt. I'm going to talk and use actual stories because you're going to remember the stories long after you've forgotten the PowerPoint, and the attorney whose last name can also be pronounced Lies. I get a lot of that. People think I did that on purpose, but I didn't. So let's get right to the program. And as we get started here, I press the button and we're going to try to advance the slides. There we go. All right, that's me. We don't need to spend a lot of time on that. Next slide. These are the program objectives, and we're going to fill your head with a lot of knowledge. But let me kind of put out at the front end here that this is not a session on how to avoid protecting your employees against workplace hazards by using sharp legal practices. In fact, it's far from that. It's the exact opposite of that. And when you get down to training your supervisors, I want you to talk to your supervisors when you have any questions in your own mind about whether or not they are going to enforce your safety and health policies by asking them this simple question. If your son or daughter or your niece or nephew were working for you, would you believe that they are protected against the hazards that you are responsible for your employees? And if the answer to that is yes, they're protected, that's the right answer. If the answer is no, then you're going to follow that up by asking, is someone else's son or daughter, niece or nephew have less human value than your own? And then I will also throw out here, and hopefully none of you have ever had a serious catastrophic accident or fatality. But if you do, you will never be the same. You can hire all the lawyers in the world, and they're not going to take away from you the feeling that you could have done something better. And in my experience over 45 years, I have seen individuals, supervisors who have significant psychiatric and other emotional issues as a result of not enforcing their safety program, and someone died or was seriously injured, including alcoholism, drug abuse, and suicides as a result of being unable to cope with the sense of guilt for not complying. So I want to get that message out front here, and I'm here to help you, but I'm not here to say you should avoid your legal responsibilities by giving you sharp practices. Next, please. So the next slide tells us, and let's go back to the beginning, because a lot of people don't understand this. When OSHA first came around in 1970, all you had to do was worry about your own employees. That was plenty. And Christina tells me we have people on this call from construction as well as general industry. So you see the specific regs at the bottom of this slide. There's about 30,000 in each one of those categories. But if you went home today and you memorized all those, you would still not be in compliance because of the general duty clause. The general duty clause basically says if there is a hazard likely to cause serious injury or death to your employees, you're aware of it, and there's a feasible means to correct it, that you must correct it. We're going to talk about examples of that, such as heat illness, such as workplace violence, such as arc flash, arc blast. But let's not be blinded by the fact, well, I don't see it in a regulation. We've all heard the phrase, if it looks like a rose and it smells like a rose, it's probably a rose. In this particular case, if it looks like a hazard and it might kill somebody, even though there's no regulation, we need to look at it. So this slide, next slide, tells us that we better start thinking a little more broadly than worrying about just our own employees. And this particularly has importance to our folks who are in the construction industry because by their very nature, they are on multi-employer work sites. What's a multi-employer work site? That's where we have a number of employers with their employees who are present. And just because you're out there with your own employees does not mean that you don't have legal obligations under OSHA to someone else's employees. And if you fall into one of those four categories under the second bullet point, you have responsibilities to someone else's employees, and particularly if you're the controlling employer. What does that mean? That means the GC. That also means a sub who has a sub-sub. So you can have responsibility there, and you can be cited for someone else's employees being exposed to a hazard, even though your employees are nowhere in the area. Several years ago out in Ohio, a Ryder Truck Company hired an outside contractor to go up on the roof because their HVAC system went out. Ryder never allowed their employees up on the roof under any circumstances. The outside contractor employee went up there using his own boom truck. On the way back to the boom truck, he fell through a skylight and died. Not only was the outside contractor cited for failure to have fall protection, but Ryder was cited under the multi-employer worksite doctrine, saying you're the controlling employer. You knew you had skylights up there. You didn't have to go up there with them. You didn't have to provide them with fall protection, but you had to make darn sure they knew there were skylights up there and they had some means of protecting their employees against that fall hazard. It can also involve criminal liability, and the leading case on that arises out of the old post office in Chicago. A number of years ago, they were putting an addition on, and the ironwork was unstable. During the course of that, the general contractor was informed that it was unstable and that the sub was not installing it correctly. It collapsed tragically and killed 2 employees, 1 employee of the general contractor, 1 employee of the sub. The general contractor was indicted for the death of both employees. They argued, wait a minute, the subcontractor employee is not our own employee. And the federal court said, wrong, you're the controlling employer. So they were fined $500,000 each. You can't send a corporation to jail because it's a piece of paper, but the judge said you're going to be barred from all contracts that are funded by federal money or state contracts that involve any federal reimbursement. So this can have real teeth in it. And so let's go to the next slide. When you're out at your work site, let's go to the next slide, look it around. Now, if you're the owner in general industry, you have other issues. If you bring an outside electrical contractor in to perform electrical work, I think you're going to want to make darn sure that they know all about the hazards of working with live electrical equipment. I've already told you about what happened to Ryder. They were not in construction, they're general industry. If you're a general, you have subs. If you have leased or borrowed employees, you must make sure that they are trained to the same extent that your own employees are who are performing the same work. And the flip of that is true. There's been citations issued that we have defended where our clients in the construction industry have loaned employees to another employer. And in one case, we loaned carpenters who were working at ground level to another company who wanted to put them up on a movable scaffold to do elevated work. We didn't train our employees in fall protection because we never expected our carpenters to be up. They were up in their elevated position. OSHA came by and we got cited for not having provided fall protection and training to our employees when we never expected them to be up on a scaffold doing elevated work. Same thing with temporary employees. So what's OSHA looking for? They're looking at the entire workplace. And in construction, it changes minute to minute. Weather, new equipment, new contractors, changing conditions on the structure, demolition, construction, whatever. So we have to have a good contract. If you don't have a good contract that talks about identifying the hazards and who's responsible for the safety and health, you need one. We have a rider. If you want one, you've got my email address. I'll send you one. You can use it as a template, but you have to customize it for your own use. If you find a subcontractor or you bring an outside contractor in and they are totally failing to comply with safety and health, do not go over and try to tell them how to do their work. You now are becoming the direct employer. You're directing means and methods. Stop the work. As soon as you stop the work, there's no exposure to a hazard. They can't be hurt. Get their supervisor over, find out what's going on, and if they don't know how to do the work, they should be removed from the site and someone else should be brought in. And obviously, if we see any employee, our own employee, anyone else in imminent danger, we are going to immediately stop the work. If it's elevated work, get them out from the elevated situation. If they're in an excavation and there's no trench protection, get them out of that. If they appear to be operating a piece of equipment erratically, get them away from there. And as soon as you do that, you've avoided OSHA liability. Next, please. So here's the scenario here. You've hired an electrical subcontractor, and you're standing there, and it looks like they're booming their equipment within 10 feet of the electrical utility lines. And for those of you who don't know about that reg, you're not supposed to get a piece of equipment within 10 feet of a electrical line unless you take certain precautions, because otherwise you can obviously have an electrocution situation. You don't even have to touch it, by the way. You can have arc flash, arc blast. So do you have an obligation? Yes, you do, depending on your situation. You need to stop the work. Have them boom down, say, what are you doing? Why are you up there? What is your training? If that employee is injured, what's the company's liability? Potentially third-party liability. What is your personal liability? If they believe you're the controlling employer and you stood there and you watched this, there could be potential criminal liability. Next, please. So when OSHA comes out to do investigations, they're bringing interpreters. We have multi-diverse workplaces where there's many different languages. Just because OSHA brings an interpreter out, don't assume that they can communicate with your employees. We've had many situations where OSHA brings a Hispanic interpreter out who cannot speak the same dialect as your own Hispanic employees. You can ask your employees, can you understand the interpreter? If not, you need to get a bilingual employee there to assist. Otherwise, your poor employee is going to be interrogated by someone they don't understand, and they're going to admit violations because of the communication issue. Repeat citations. If you get an OSHA citation and you decide, well, you know what, it's not worth the trouble, I'm just going to send in the penalty, you may have put yourself into the magic circle, because there's a 5-year time period now for repeat violations. They can go to any one of your work sites anywhere else in the country, or that same work site in 5 years, and if they find a substantially similar violation, you're going to get a repeat. And for those of you who don't know, if you go in to meet OSHA and they reclassify a citation from serious to other, a lot of people think you're out of the woods. No, you can get a repeat citation off of another. Cautionary tale, previous inspection. OSHA now is doing a lot of inspections by letter. They send you a complaint and they ask you to provide certain information. We have a complaint that employees are exposed to a substance. We have a complaint that there's unguarded machines. And you send a letter back to OSHA saying there's no unguarded machines, we have no substances, whatever else. And they come out and they find that machine is still unguarded, or they find that condition. You're not looking at a serious violation, which is based on a mistake. You're looking at a willful violation. And if they think you intentionally lied, as we talk about a little bit later here, lying to OSHA is a felony punishable up to 5 years. They're also going to give you a nice little letter with the American Eagle on it. Just because the American Eagle is on it doesn't mean everything in there is that you're required to do. They're going to ask for your root cause analysis and your company insurance audits. You have no obligation to do root cause analysis or have insurance for OSHA purposes. If you turn over those root cause analysis or company insurance audits, they can use those to cite you. A number of years ago out in Rockford, we had a client who had an unfortunate accident where a young lady's 2 hands were amputated the first day on the job on a press brake. OSHA came out and asked for all the insurance audits from Liberty Mutual. They went back 7 years and found out that every time Liberty went out there, they said the press brake was not properly equipped with an anti-repeat mechanism. And that's exactly what happened. The woman reached back in again to pull the part out. The machine repeated and took her hands off. They got 7 willfuls as a result of that. So you can push back and say, I'm not going to turn that over. Now, as far as the root cause analysis, if you decide to do one of those and you've had a catastrophic accident, I would highly recommend that you do that with legal counsel. They can create the attorney-client privilege as well as the work product privilege, and they can protect your root cause analysis so OSHA can't get it even with a subpoena. We're going to talk about the severe violator program, which is basically a blacklist where OSHA takes control of your company for a period of 3 years and raises havoc. We're going to talk about the new penalties. They revised their penalty structure. It had been basically sitting where it was since 1986. It was just readjusted several weeks ago. and I'll show you a matrix on that. We have to start dealing with non-English speaking employees in terms of our training, and we'll cover issues relating to record keeping and the revised record keeping rule. Next, please. So what else can they do? If they come out and they find, for example, that you are not enforcing your PPE rule, people are running around without hard hats, or if you're in a plant, they don't have their eye protection on or their protective footwear, they can cite you per employee if they want, as opposed to grouping. A number of years ago in Pennsylvania, employees were not wearing respirators properly in a lead environment. They had beards. They weren't keeping the respirators clean. OSHA gave them 276 individual willful citations, $5.3 million. They can put real teeth in that. Lockout, tagout procedures. How do they come after us on that? I hope you know that your lockout, tagout procedures have to be reviewed annually. And you have to have a certification that says each lockout, tagout procedure was reviewed annually to make sure it still works. So what do? They will ask one of your employees who's an authorized employee to lock out a machine using the procedure. If the procedure doesn't work because you didn't do the annual evaluation and you go through the steps and the machine is still hot or live, you can get cited for each machine. If your employees have not been properly trained on the new procedures, they can cite you for each employee. So the days of, I'm going to get one here and one there, those are over with. Now, I told you what the general duty clause is, and it basically is a catch-all for hazards where OSHA doesn't already have a standard. So what is one of them that may affect some of you? Combustible dust. Those of you who are in manufacturing and are working with paper, with metallic fines, organic material, sugar, any type of powders, and you're in a confined area, and there's a potential for an ignition source, they've got to determine whether or not that dust is combustible. And basically what happens is one or two of the particles ignite, followed by immediate, what's known as a deflagration. Every particle in the entire space explodes, with catastrophic results. 7 years ago in Georgia at the Imperial Sugar Company, they were cleaning an area out. There was sugar dust. They had an explosion. It leveled the plant, killed 12 employees, and caused $200 million worth of damage. So if you have any type of combustible dust in an area, what is too much dust? Too much dust is a dime laying on its side, and the dust is deeper than the height of the dime. Dust on a piece of paper. You can't read the piece of paper. That means you don't have good housekeeping if you have combustible dust. Ergonomics, a fancy word for the study of work. OSHA will ask to look at your logs. They will ask to see whether or not you have employees who have frozen shoulders, bad backs, carpal tunnel syndrome, although carpal tunnel syndrome can be caused by 26 different stressors having nothing to do with work, including pregnancy, diabetes, et cetera, et cetera. But they will look at that and they will say, I want to go see that job. And if you have employees doing repetitive work, they're bending over all the time, they're in awkward positions, they're using tools where they have to pull a trigger all the time and it pinches off the blood in their fingers so they get white fingered because the cells are dying in the tip of their finger, they're going to look at that. So your log is a mirror looking back at you. You should be analyzing that job and find out it. Get yourself a competent occupational physician who knows something about cumulative trauma and have them come in and look at it. Workplace violence. Tragically, we saw a situation last week at a school. It's unfortunate. The statistics tell us that 1 out of every 5 of us Americans every day is capable of workplace violence because we have physical, mental, or emotional conditions, substance abuse, financial problems, drug abuse, alcohol abuse, whatever else. So OSHA's looking at that. They won a big case down in Florida, which kind of tells you what they're looking at. And by the way, there are certain target industries. They've gone after all-night retail. They've gone after the taxi cab industry. They've also gone after healthcare, particularly emergency rooms and psychiatric units where you have people by their very nature who cannot control their emotions. In this particular case, a young woman got out of college, got her first job, worked for a healthcare organization in Florida where she went out. She was a caseworker going to people's homes to make sure they were taking their meds to see if they needed to come in. And she started feeling very uncomfortable going to this one particular individual's home. The healthcare facility did not tell her that this person had a history of violent activity. She kept going. Every night she reported, said, I feel afraid. Can someone please come and help me? I don't know what to do with this individual. Nothing was done. Finally, she showed up. He came out with a butcher knife. He stabbed her 8 or 9 times. She fell in his front yard, dying. He sat down on a chair, lit up a cigarette, and watched her die until someone called 911. The judge basically said, there is no excuse not to have a workplace violence policy now. You can tie it in with your anti-harassment policy. No one should be subjected to threats. And let's not think about workplace violence as being guns and knives. It's a lot more than that. It's threatening emails. It's pictures. It's getting in someone's space, getting close to them. There's a bullying. It all falls into that category. If you don't have a workplace violence policy, send me an email. I'll send you a template. But you must fix it for your own circumstances. New chemicals. You know that we're getting new chemicals in all the time. Don't assume that just because you have a similar type chemical, all the hazards are the same. What you need to do is to go through it very carefully and make sure that you're below the permissible exposure level, that you have the right PPE for your employees, that you're storing it properly so it's not going to explode or become flammable. Arc flash, arc blast. Arc flash is basically lightning. Arc blast is the thunder. Electricity is the plasma. It moves through the air. You don't have to touch it when it's live. And if there's arc flash, where an electrical panel, you come near to an electrical panel and you have an arc flash, the electricity travels through the air. When the flash actually hits, it's 35,000 degrees. If you are not protected with flame retardant clothing, face shields, all the necessary other equipment, you will suffer catastrophic type of burns. That's followed by the arc blast. That's the energy or the thunder that we feel when everything starts shaking. The arc blast will be the melted electrical panel spraying all over you, nuts or bolts, and things of that nature. We have settled cases where people have not put on their PPE and they have gone to work near equipment. And it is, in one case I'm thinking of in Madison Square Garden, it was a young woman. And as a result of that, she lost her ear and her face is horribly deformed for life because she did not wear the face shield, the eye protection, and the flame retardant clothing. Now, there's a little catch here. Most employers say, well, I never do live electrical work, so I don't have anything to worry about. The answer to that is yes, you do. Under NFPA 70E, the National Fire Protection Association National Consensus Standard provides, and OSHA enforces it, even though it isn't a reg, they use the general duty clause. If you lock a piece of equipment out that has electrical energy and you take a voltmeter to go see whether or not it is in fact de-energized, that act is considered live electrical work. And if you're above 50 volts, depending on the voltage, you must have rated flame retardant clothing, a face shield, eye protection, hearing protection against the arc blast, which will blow your eardrums out, a insulated helmet, insulated boots, insulated gloves, insulated tools. Heat illness. This is another big issue. We tried a case for 18 days and beat OSHA 2 years ago in a case, but they're all over this. And most employers don't give a lot of thought to it. Well, you need to. One out of actually almost 40%, somewhere between 40 and 45% of our fellow Americans are obese. What does that mean? That means that their cardiovascular systems aren't in very good shape to cool them off if they run into excess heat. It also means if you got a nice fat belt around the middle, that's a great insulator. So it holds in your metabolic heat, which is generated by the work you do. So you need to explain to your employees, if you're going to have them working outside or performing work that requires exertion, that heat illness is composed of 3 things: the raw temperature outside, the humidity, and how you have them working. Are they picking things up? And by the way, you can have heat illness inside a cooler or refrigerator. If employees are inside and they're wearing clothing to protect them against the cold, and you have them doing heavy exertion, they're heating up and the heat's not going outside, they're cooking inside. OSHA expects you to tell them about the 4 types of heat illness, starting out with heat rash. That's the first indication. Your clothes are too tight, the sweat can't get out, and you're getting the bumps around your neck, followed by cramps. You're not getting enough nutrients and moisture to the muscles, followed by heat exhaustion. Your body is struggling to cool itself off. You're sweating profusely, and you're starting to become disoriented, followed by heat exhaustion, which basically means that your blood, which is a plasma, which carries heat from your internal organs to your veins, to your capillaries, and evaporates it, your blood turns into a solid. Once it turns into a solid, it doesn't carry heat. Just imagine the engine in your car and the coolant freezes solid, or your whatever else it is. You're going to heat up, and in a very short period of time, you're going to get up over 100 degrees. And once you get up to that level for a certain period of time, there is permanent brain damage, and basically there's nothing they can do for you. You go from heat exhaustion to heat illness. OSHA expects you, and they come out, they're going to be coming out when it starts getting warm. They're going to be asking you, are you monitoring the heat using the NOAA, the National Oceanic Aeronautic Association, or are you using OSHA's app that shows what the weather temperatures are? And do you have water? Do you have ice? Do you have Gatorade? For those employees who are diabetic, do you have powdered electrolytes? Because Gatorade will kill them if they're diabetic. But Gatorade does have electrolytes. And are you observing them? And if you see someone who is starting to sweat profusely and struggling, are you going to pull them out of service? And are you going to provide first aid for them? This is a big issue, and they're all over this. Fall protection, OSHA's now adopted more stringent rules in general industry for fall protection over 4 feet. And then finally, the PELs. If you are using a chemical and it has a permissible exposure level, and you are at or below that level, you are not home free. OSHA's position is, if they come out there and they look at the safety data sheet and there is a lower level by the ACGIH, the American Congress of Governmental Industrial Hygienists, that says that it's more protective than the PEL, OSHA can cite you for that, and they have done it, saying our own regulations don't protect employees. Next, please. Okay, I'm not going to spend a lot of time on crystal and silica, but the rule is in effect. It's been in effect already for the construction industry. On June 23rd of this year, it starts to kick in big time for general industry. Basically, if you are performing any type of work where you are generating crystal and silica, which once it gets into your lungs, it scars your lungs. Eventually, your lungs develop tumors. It's also a very good breeding ground for tuberculosis, and ultimately you will die of a respiratory type disease. So they have, please go to the next one. I'm not going to spend a lot of time on this, but they have construction and general industry. Both of them became effective on June 23rd. There's 1 to 5 years depending on the industry. Next, please. So as we see here, general industry, June 23rd, 2018, and various things kick in. If you're involved in hydraulic fracturing, you got more time on that. Next, please. So we have to do medical surveillance if our employees are exposed more than a certain period of time above the permissible exposure level or the action level. That kicks in later in general industry. Next, please. They're lowering the levels. The action level is 25 micrograms. The permissible exposure level is 50. It's a significant drop. They will expect, if you're out there using a saw to cut concrete, or you're cutting tile, or you're doing anything else that's generating a dust, I want to see your silica dust exposure control plan. Next, please. So we've got to protect our workers in these areas and make sure. We also have to establish a regulated zone where these exposures exceed the permissible exposure level, and nobody goes in there. Next, please. We're going to have medical exams and maintain medical records as we go forward on this. Next, please. Respirators are going to be required, although OSHA's initial position is you have to use engineering controls. What's engineering controls? Exhaust, wetting down the dust so that it doesn't get airborne. If you exhaust or it's wetted down, you can't inhale it. And you've got to keep records of the exposure. Next, please. Keep going. These are some of the requirements in the construction industry. If you're performing these various types of activities, you must do it this way. And you see on the right-hand column, if you perform that function, then you can use certain types of respirators. Next, please. These are more examples of this. Next, please. I'm not going to go through all of them. There's many, many tables. Let's go through the record-keeping regulation. Nope, got to go back. Okay. We all know, I think, that if we have an employee die, we have to call OSHA within 8 hours of becoming aware of that. That also applies to heart attacks. If you have an employee who's sitting at his desk and basically sitting at his desk and has a heart attack, a lot of people say, well, I don't have to call OSHA. He just died sitting at his desk at a heart attack. Wrong. You have to call him within 8 hours. You call the local area office. If it happens over the weekend, dial into OSHA. There's an 800 number in Washington, D.C. They'll call you back. They changed the rule several years ago about other types of injuries. If you have an employee who goes to the hospital for treatment, the word treatment is very important. If an employee gets a good whiff of carbon monoxide because they're working around a forklift and they go to the hospital and the doctor says, sit in the corner and put a mask on, I'm going to pump you up with oxygen and I'm going to watch you. And then they let them go. That's not treatment. You don't have to call them within 24 hours. If they go there, however, and they get some initial stitches, and then the doctor says you got to come back, and within 24 hours they admit them to amputate the rest of the finger. Now they've been hospitalized for treatment. An amputation, in the case of an extremity, it doesn't mean loss of a bone. But if you have an amputation, you have to call them up. Loss of an eye, that doesn't mean I got metal slivers or chemicals in my eye. That means the eye is gone. That's called within 24 hours of the incident. Now, let's assume that an employee cut his finger. He goes and gets stitches within the 24 hours. At 24 hours and 1 minute after the accident, the doctor amputates the finger. You do not call OSHA. The amputation did not occur within 24 hours of the incident. Let's keep this very clear. Now, by the way, this rule has nothing to do with your obligations to put things on your log, and I think you're all aware of that. Next, please. This is some of the stuff that OSHA is going to ask for if they come in for an investigation. Obviously, they have a right to get the 300, the 300A, and the 301, and their reg says 4 hours. So if they're asking for a bunch of documents, you say, hey, wait a minute, I want you to put the request in writing. Just write it down. I'll give you the original back because I want to know what you're asking me so you don't cite me for not giving you something. But ask them, do you want the 300, the 300A, or the 301 in 4 hours? And you'll stop everything else you're doing. If you don't do that and you send them a bunch of documents the next day, they may cite you, and they have done that. It's kind of chicken poop to do that, to cite you, because you didn't give them those in 4 hours. Medical records, you don't have to give them any medical records unless you maintain the records. Work comp records, no. Insurance records, no. Payroll records, no. Company safety incidents, yes, you have to give them the 301 that relates to each entry that's on the 300 log, but you don't have to give them your internal accident reports. First aid logs, you don't even have to maintain a first aid log. Alternate duty rosters, no. Disciplinary records, yes, should do that because that shows you're enforcing your program. But just because you get a letter from OSHA with a nice little American Eagle sitting up in the corner doesn't mean you have to turn all this over. And if you do, you can be cited for stuff in there that maybe shows there's a problem with your program. Next, please. Okay, the record-keeping rule, and basically they delayed the enforcement until December 1st of 2016. They came up with some new protections. Next, please. So basically, what do they say? There's 3 points you got to think about. In the old days, a lot of employers had programs say, unless you report the injury or illness to me immediately, I'm going to discipline you. So the example is an employee feels a twinge in their neck, and they keep working, and a week later, they can't move their neck at all. They come in and tell you that, geez, it started back then, and you say, you know what? I'm going to suspend you without pay because you didn't report that in time. You can't do that anymore as long as an employee reports to you when they reasonably believe they had an injury or illness. So you can certainly do an inquiry and find out if they've been lying to you, but you need to take that into consideration. Why is this a problem? We don't like this rule because the reason that you wanted to know about the accident immediately is so you could investigate it. You could go out and look at the scene. You could talk to eyewitnesses before people forget. So we don't believe this is in the best interest of safety and health, although there are some times when employees have been hurt and they don't fully realize it. The next thing is incentive programs. If you have an incentive program where people get cash awards, or a manager's compensation is based upon having no recordable injuries or illnesses, they are going to look at that very closely. Why is that? They think that the purpose of that is to encourage employees not to report injuries or illnesses, because if you report them and they're recordable and they go in the log and OSHA finds out about them, there could be a problem. So they think that the bonuses based upon recordable injuries or illnesses are a subterfuge to tell employees not to report injuries or illnesses. They cannot outlaw that. You could still do it. But we still believe that you should have in your policy an anti-retaliation phrase that says if you report an injury or illness, you will not be punished for reporting an injury or illness. By the way, that doesn't mean you're not going to discipline them for violating a safety rule. The last one is post-accident mandatory drug testing. And OSHA, this one, we are still shaking our heads, and this may not survive the new Secretary of Labor for OSHA once he gets confirmed. He's gotten through vetting, but he hasn't been confirmed by the Senate, and he comes out of industry. A gentleman by the name of Mr. Mugno, who was formerly an attorney with the Judge Advocate General's Corps, and also a attorney with FedEx, responsible for, among other things, safety and health. Post-accident mandatory drug testing, only drugs. This does not affect post-accident alcohol testing. OSHA's position is if somebody comes to you and they were involved in an accident and there's injury, that you cannot perform a drug test unless you have a reasonable belief that drugs somehow played a role in the accident. I submit to you, you have to be Svengoolie to be able to figure that out, unless there's a syringe sticking in the employee's buttocks or they've got white powder coming down their nose. So what are you going to do? You're still going to do your post-accident mandatory drug testing, but you're going to come up with a little write-up. You're going to talk to employees and say, okay, did Mark Lease act unusual before this accident? Was he driving his forklift in circles? Was he talking strange? What was he doing? So that you have some evidence that I might have been impaired by drugs, and you send me out. But when in doubt, it's our recommendation, send people out to find out whether or not it's involved. We find out, and this is another statistic that's very troubling, anywhere from 20 to 30% of your workforce on any given day is under the influence of drugs or alcohol. You just don't know it. And as far as drugs, that's illegal drugs or abuse of prescription drugs. Next, please. So these are the anti-retaliation policies, and adverse action means you terminate them, you punish them, et cetera, et cetera. I think we all know what that is. Next, please. If OSHA believes that you've retaliated against employees, they can seek reinstatement to the employee's job, back pay, and other relief. And we believe this rule conflicts with your duty to promptly investigate accidents and take disciplinary action. Next, please. I've covered this already. Let's go to the next one. I've covered this one already too, because I want to get, here's the, as far as the record keeping rule. OSHA initially said that if you had 250 or more employees, as of December 15th of last year, you had to file your 300, your 300A, and your 301. If you had 20 to 240 employees in designated high hazard industries, you had to file the 300A, and finally, OSHA can always make an individual request for your logs. That rule was changed somewhat, and the date was pushed back till December 15th of 2017, and all that anyone had to file was the 300A. This rule is now going to be under challenge as far as whether or not OSHA should be able to do that. What were they going to do? They were going to take all that information and make it available publicly on their website. So people who wanted to organize you, plaintiffs' attorneys, people in the neighborhood who don't know what you're doing in the plant and realize, oh my gosh, people are getting hurt inside the plant because they're exposed to a substance that might be blowing right out through the loading dock into our neighborhood. could come in and challenge you. So right now, OSHA is sitting on the 300 days. They've already been sued by a public interest group saying you must turn those over. Thus far, OSHA has not done that. More to follow on this as far as whether or not this rule survives at all this coming year and who needs to file. But I just want to let you know that's out there, and that why it makes it even more important that your OSHA logs be correct, and you shouldn't have stuff on there that doesn't belong on there. You can be cited for putting too much on the OSHA log as well as not enough on the OSHA log. And if you put all kinds of things on there that aren't recordable, in other words, somebody sneezes and you put that on the log, that doesn't belong there. And if OSHA looks at it, they will say you have no idea how these rules work, and we're going to cite you for failure to follow our record-keeping rules. Next, please. Christine is my crack help here. She's getting carpal tunnel syndrome, moving my slides for me. If you have a record-keeping inspection, this is what they're going to look for. They're going to go to the record keeper. So you better make sure your record keeper knows how to fill out the log. Then they're going to take your log and they're going to walk around the plant to where those injuries occurred. So why don't you do that before they get there and make sure you've addressed the hazard so the accident won't happen again? And the problem is also when they walk around doing this, if they see something else, they can expand the inspection using the plain view doctrine because they see a hazard while they're walking around. Next, please. Okay, what are the types of violations? This is for OSHA record keeping as well as citations in general. And other than serious citation means that if someone were injured, and you don't have to have an injury to have an OSHA violation, it would not be life-threatening. Serious means it would be life-threatening. So an other than serious is a cut with stitches. A serious is an amputation. Both an other than serious and a serious are based upon mistake. Somebody made a mistake. Then we start moving up into the high gravity ones. A willful one is where they can prove that a supervisor knew that a regulation was being violated. In other words, he walks by a machine every day, sees people putting their hands near the point of operation, knows that the guard has been missing for years, and says, keep working. That's a direct order. That's a willful violation. Or doesn't give a direct order, but knows the guard is missing. That's conscious disregard. I just don't care. That's a willful violation. A repeat violation means a substantially similar violation anytime in the next 5 years at that location or anywhere else. Failure to abate means you got an OSHA citation, you either settle with OSHA or you didn't contest it, and you just decided, I'm not doing anything about it. So that same violation is there. That's failure to abate. We have criminal liability as far as the OSHA 300 log. The 300 log requires, it's an official government document, and if it's being filled out falsely, there's potential criminal liability for the employer, as well as the management representative who files a false certification. And as you all know, every year from February 1st till April 30th, the OSHA 300A, which is the annual summary, it's a one-page document, has to be posted at the workplace. And it has to be signed by the senior management representative who is there. If that person signs it and they don't take a chance, they don't take an opportunity to look and see if the information is false, and OSHA comes in, that person is looking at a false certification, which is a felony. Next, please. These are the penalties. They just jacked them up again about 2 weeks ago. They're the other than serious and the serious are just shy of 13,000. The willfuls have gone up. They're just shy of 127,000, as well as the repeats. They're going to go up every year based upon the consumer price index. And as I told you before, if they decide to give you heartburn and cite you for each employee versus grouping all the employees, you can get a citation for each employee. Next, please. Let's make sure that we're okay with our globally harmonized system. That's our OSHA has a communication standard. The time is long past where you had to have your new safety data sheets. You had to have them all by June 1st. The time is long past when your employees have to be trained about what a safety data sheet is and how to read it and where to find them during the off shift if the foreman isn't around. or if you keep them electronically at a kiosk somewhere, what's the password so they can get in and see them? But they will come out and they will ask your employees, did you ever hear of a safety data sheet? If the employee goes, what's that? You have a problem. Did they tell you how to read one? No. Did they tell you where you can get a copy? No. And by the way, your employees are entitled to get a free copy of the safety data sheet so they can take it to their healthcare provider to see whether or not you're exposing them to a substance that's likely to cause an illness for them. So let's make sure we have all the new safety data sheets. And by the way, do not throw out the old material safety data sheets. Why? Because if someone comes up 20, 30 years from now, particularly in Illinois with an occupational disease with a long latency period and says, I got a cancer working with XYZ chemical, and you pull out the safety data, the material safety data sheet that now is 30 years old and says this material is not a carcinogen, you win. You're not going to pay that occupational disease claim. If you threw them out, the company doesn't exist, you can't get one anymore, you can't get labels, you're already in trouble in terms of a occupational disease claim. Next, please. The severe violator program is just what it is. It's a blacklist. It started in 2010. Next, please. And basically, this is how you get in. You have to have 2 willfuls, 2 repeats, or 2 failure to abate violations, or a combination. And then you have to have a fatality or a catastrophe. A catastrophe is 1 or more employees going to the hospital for treatment. You're in a high hazard industry, so most of you have amputation hazards. Most of you have fall protection issues. You have people up on catwalks. You have them on top of equipment. Some of you have process safety management, or you've been in trouble with OSHA before. Next, please. What happens when you get in there? They start going to all your locations around the country. They put a really nasty press release on their website, and they send it to the Tribune and the Sun-Times. If you want to settle with them, you're going to have to hire additional safety people to come in and work. You're also going to have to audit yourself and submit reports to them. And you're going to have to agree to Section 11B language. What is Section 11B? That's part of the statute, and it says if they think you're not complying, they can bring the federal marshal out, arrest a senior management representative, take them to the federal courthouse, the Dirksen building in downtown Chicago in front of the Court of Appeals, have them held in contempt of court, have them take off their street clothes and put on an orange jumper, and then go to the Metropolitan Correctional Center. And that happened 2 years ago to a guy from Rockford who was involved. He settled a case involving employee exposure to fiberglass. And he wasn't paying the penalties, and he wasn't doing what he was supposed to do. They gave him notice. He didn't do anything. They picked him up. He ended up spending 2 weeks and making brand new friends at the Metropolitan Correctional Center with a stylish orange jumpsuit and shackles. So we don't want to run into that problem. It's a blacklist. And I will tell you right now, I have a case in the office under this where it's a client who's very, very responsible, but they got citations for $622,000 in Ohio. They're a foundry. And the citations were based on repeat citations from citations within the last 5 years in Kansas, Illinois, and Alabama. They rolled them together and they came up with a violation, and they said, you owe us $622,000. You're in this program for 3 years, et cetera, et cetera. We're fighting that right now. You do not want to get in that. If you do, your name is posted on OSHA's website. They have a severe violator log, and I will already tell you what happens to your business. People see your name on there. They stop doing business with you. Your competitors see it. They badmouth you. You're going to have a problem. Next, please. Native language requirements. Okay, right now, you can train your employees in English. You don't have to train them. There's no regulation. However, here's the problem. You train them in English, and they don't speak English. You give them written materials, your PowerPoint, your training materials in English. They can't read English. Or you translate them, and they can't read their own language because they never went to school. In the meantime, you've certified, as you're required to under many regulations, that they're trained. If OSHA comes in, they will ask for the personnel folders of employees who have Hispanic, Polish, other surnames. They will pull the records out where the employees have signed off on training, and they'll ask the employees, can you read this training? No. It's in English. I can't read English. Can you read this training in Spanish? No. I can't read it at all. I was told to sign the bottom. You now have a training record that is not a training record, and you also potentially have a false certification. So what are you going to do in this situation? You can ask your employees if they can communicate in English, written or verbal. And if they can't, you get a bilingual employee to walk through the training with them, and you get them both to sign off and date it, and then you can prove that your employee was trained. This is a huge source of citations. And many times we get OSHA complaints. We get a complaint letter that says employees who are Hispanic speaking cannot understand the training that was provided to them. So keep in mind, this is an issue here. Next, please. What's even worse than that? Literacy. You go to all the trouble to put together a nice training program, PowerPoint, et cetera, and your employees can't read it, your English-speaking employees, because, for example, in the Chicago Public School Districts, we have anywhere from in high school, a 60 to 70% dropout rate. So we have people who are tragically, functionally illiterate. So if you put down a program in front of them, ask them to read it and sign that they were trained, and they sign it and they say, I can't read, you don't have a training record. That's why you need to ask them that. You may need to break it down, and you may have to use more visual aids, such as pictograms, all over the place to tell them what the hazards are. Next, please. Here's our criminal law liability. Right now, under the federal system, if you kill an employee, in other words, they die at work, there's a specific regulation. They can't use the general duty clause, but they can use lockout, tagout for electrocutions, amputations. They can use falls. They can use trenching, confined spaces, which turn out to be tombs in many cases. And they find out it was willful based upon what a manager gave a direct order or knew it was happening. They're there. They've got it done. 6 months imprisonment. Companies don't go to jail. People do. $250,000 against the manager, $500,000 against the company. Just so you know, so you realize if you're acting in good faith, and that's all we can expect anyone to do, your employer has a legal obligation to hire competent legal counsel and vigorously defend you. If you lose, they cannot pay these fines. It's against public policy to reimburse one employee for killing another employee. Also, you cannot get them paid under your homeowner's insurance. That's against public policy. You can't buy insurance to kill people. That makes common sense. You can't deduct it on your insurance policy, on your income tax. And by the way, there probably won't be any income tax deductions anyway. So you're kind of screwed, to put it mildly. That's why we don't want to allow conditions to exist. Why do I have Miranda warnings necessary? If there is a fatality or a serious injury, you know the employee's going to die, particularly in the case of burns, 50% burns, they survive 6-7 months and they die of sepsis. If OSHA comes out and says, what happened? Tell me about this. And you do a core dump saying, oh, I knew about this. I knew that guard wasn't there. I should have done something about it. The requisition to buy one's been on my desk for a year and I just never submitted it. What have you done? You have just waived your Fifth Amendment rights and you admitted that you acted willfully. They do not have to give you the Miranda warnings that you have a right to remain silent and anything you say will be used against you, because that only applies when you're arrested. A compliance officer cannot arrest you. They have no arrest authority. So you have just done it to yourself. And a lot of times after an accident, and there's a natural human reaction to feel guilt and want to express that, legally, you can waive your Fifth Amendment rights. If you have a serious accident or someone's about to die or has died, you need to get competent legal counsel, because as I will talk about in a few minutes, you don't even have to talk to OSHA. They can't force you to talk to them. Next, please. Let's keep going because we're running out. What time is it? Yeah, let's keep going. It's almost 11. Whistleblower laws. If an employee comes to you and makes a complaint about unsafe conditions, and you do anything to punish that employee, or they work with OSHA, they file a complaint with OSHA, or they walk around with OSHA and point out hazards, and you punish them, that's a violation of Section 11C. They can file a whistleblower complaint. Next slide, please. And what happens? They can file suit against the company and you personally. OSHA will investigate, and if they find out that there is a violation, if they find out that the retaliation occurred, the employee will get their job back with back pay. Next, please. So where do we go from here? We want the unavoidable employee misconduct offense. See what's italicized there, unavoidable. It's not just an employee acted against your rules, it's you did everything to avoid it. So what do we have? You have to have a program for every hazard at your workplace. You have to do training. I've already talked to you about documentation and language and literacy issues. You have to have prior enforcement. You need to tell your supervisors they have skin in the game. If they don't write people up, and it comes to an issue about did you act in good faith, did you enforce, and there's no written discipline, as far as OSHA is concerned, it never took place. And item number 4 is on the time of the accident or when OSHA is there, if there was no opportunity for a supervisor to see it and stop it, it's not a legal violation. Next, please. So how do we do this? We do a good hazard assessment every day. Your shops change, the work site changes. We make sure people are trained, okay? And we do retraining. We forget 10% of everything we learn every week. We have to be retrained. It's just the way the brain works. It goes from short-term memory to long-term memory. You may need to use translators and interpreters and document that and write people up, okay? I'm not trying to make people's lives difficult, but if you don't write it up, you don't know the date, you don't know the time, you don't know the violation, you don't know what occurred. And then keep all those records. Okay, we're about out of time, so now I'm going to do the inspections. When OSHA comes out, and I'm just going to kind of fly this one, okay, because we're running out of time. When OSHA comes out, they can come out for 3 reasons. 1, you called them. Somebody died, there was an amputation, so you know they're coming out. 2, an employee files a complaint. 3, they come out for an enforcement program. We're coming out to look at Silica. We're coming out to look at forklifts. When they show up, you don't just let them start wandering all over the place. You take them into the conference room and you say, why are you here? Just as you would if they showed up at your house. If they have an employee complaint, you're entitled to see it. They won't tell you the name of the employee who complained, but you're entitled to see it. They must wait a reasonable time to let you talk to your senior management and decide whether you're going to allow the inspection to occur. Assuming that they pass muster on that, then what you're going to do is you're going to allow the inspection, but you're going to keep it within the scope of where it should be. So if an employee fell off of a piece of equipment and you reported it because they were hospitalized, that's where you're going to go. You're not going to do a wall-to-wall walk through the entire place. If you have to walk out of the plant and walk in a side door to get to that area, you do that. Every place you walk them through the plant, they can cite you because it's in plain view and you voluntarily allowed the investigation. So why are they there? And then what's the scope? And you keep them within the scope of that. Now, the next part of it is document requests. They're going to ask for documents. Tell them to put it in writing. If they decide to get snippy about it, you say, okay, if you won't put it in writing, I'm going to write down what you told me. And then I'm going to ask you whether or not each one of these is what you asked me for. Then you're going to review it with management, decide whether you're going to give it to them. Okay, and certain things we've already talked about, you don't have to give them to them. The third piece of the inspection is employee interviews. 60 to 70% of all OSHA citations are from word of mouth. A manager admits a violation or a bunch of employees say that there's hazardous conditions. Guess what? Your employees don't go to law school. Guess what? They've never done this before. And guess what? If you don't tell them what their rights are, then how are they going to competently go through these interviews? Now, OSHA has a right to talk to any one of your employees, but your employees, because this is still America, have a right to say, I don't want to talk to you, and they don't have to give a reason. But you need to tell your employees that. Pull them aside, explain it to them. If you don't know this, I have a document, a crib sheet I can send you that you can use called Leveling the Playing Field, so you can explain this to your employees. Now, as far as the actual interview themselves, the employee must tell the truth. It's a felony. The employee has a right to have someone with them if they want. The employee doesn't have to sign a statement. There's no punishment whatsoever for signing a statement. If they do decide to sign a statement, they got to make sure that it's correct. And before they sign it, they should tell OSHA, I'm going to sign it, but you got to give me a copy. Otherwise, if you sign it, you don't do that, they'll say, I can't give it to you, it's part of the file. And don't fall for this trick. Sometimes the employee says, I don't want to sign it. And then OSHA turns around and says, well, don't sign it, just sign it saying you won't sign it. Well, now you've signed it. So you don't have to sign it. We don't recommend that people sign it. But you can prep your employees. It takes about 5 minutes to do that. Pull them aside, explain to them what their rights are so that when they go in there, they understand. But the critical issue is they must tell the truth. And what's the truth? Their own personal knowledge. So if somebody died and the employee who's being interviewed wasn't at work that day, and they say, what happened in the accident? The answer is, I don't know. They cannot possibly have personal knowledge. And if they volunteer something, it's gossip or hearsay, and you get in trouble for that. So it makes the interviews very short, and they're truthful all the time. But I cannot emphasize enough that you need to take a little time out. Don't start rushing around. Don't go to panic and say, oh my God, OSHA's in control of the workplace. We have no rights. Absolutely not. Obviously, if you get a citation, you have 15 working days to go in and see OSHA. The 15 working days starts the day after you get it. You don't count holidays. You don't count weekends. Once that 15 working day passes, you're done. It's a final federal order. If it's totally wrong, too bad. You own the money. You own the money, and it's a violation. So, Christine, I think that kind of covers the general areas. What do we have as far as questions?
All right, excellent. I would like to remind everybody that you can use your chat box to ask Mark any questions. I also want to remind you that we will be sending out a recording of the webinar. I suspect you are going to want to send that out to people who were not in attendance. Mark mentioned his article on leveling the playing field. We'll be sending that out as well.
Workplace violence policy. We'll send that one out too. I'll send that to you. You can send that out to them.
Okay. So lots of takeaways from this webinar. If you don't already receive Mark's articles, I would highly suggest that you sign up for those. They are valuable, free legal information about OSHA and complying with health and safety standards. So let's see if we have any questions. Yes, I will be sending out Mark's contact information. We'll just watch for a couple more minutes if we get any others.
Don't be shy. If you want to ask a question and you want it to be anonymous, okay, just say I have this friend who looks like me and dresses like me. And since I can't see you anyway, it's going to be anonymous, and I'll answer your question. If you have questions after this session, a lot of people are shy, so they send me an email. That's fine too, okay? And if you don't have a friend, you can ask me anyway, okay?
Okay, so will Mark do OSHA training classes for our employees? Well,
do I do them?
Go ahead.
Yes, I do these training programs. I do them in person or I do webinars, if that was what the question was.
Okay, so yes, he will do training sessions, he will do webinars. I do want to mention that Corkill Insurance does have a safety department. We also provide both supervisory and employee training, OSHA safety compliance audits to see where your programs are at and if we need to beef those up a little bit, DOT compliance audits, construction, job site inspections. So we're there to help you as well.
And I would say that you should use those resources from Corkill. They're very, very good. It gives you a chance to maybe think about something that had not occurred to you. And they keep current, so they can be very helpful for you.
So now we have questions pouring in. We have one, does a forklift require an alarm or light when backing up?
Okay, if the forklift is equipped with a safety device, the safety device must be maintained. Horns, yes. Backup lights, if it doesn't come equipped with it, no. And OSHA will cite you if you have safety devices that aren't functioning that came with the equipment. And another area on that, while we're on that, is wearing seat belts. If there's seat belts on the forklift and the manufacturer's recommendation says wear them and people aren't wearing the seat belts, I guarantee they're going to cite you. And if you are missing your checklist in the morning before they take it out, you don't have to have a written checklist, but if they haven't checked it out and they find out that the mast isn't working or the brakes aren't working, the employee says, oh yeah, I never check it out in the morning, now you got a serious problem.
And about mirrors? Mirrors required?
Mirrors are required if they are a part of the original equipment.
Okay. So we have another question. What is the validity of the general contractors requiring employees to sign an end of shift? I did not get injured today, and I did not witness any injuries. Ergo issues developing over time, etc.
Okay. You could have someone sign that document, but I will tell you that it probably has no legal enforceability, because an employee under the Illinois Workers' Compensation Act is not capable of individually waiving their rights. The only way they can waive their rights to workers' comp benefits is formally in front of the Illinois Industrial Commission. Now, could you use that document to argue, well, they didn't tell us about that and we didn't have a work-related injury? You could try to make that argument, and that's why a lot of employers use it. But in terms of a bar to a work comp claim, it's not going to save you with the Industrial Commission.
We have a question about safety data sheets, and do we need to keep a hard copy of safety data sheets as well as keeping a database?
Good question. No, you don't have to keep a hard copy, but because they need to be reasonably available. That means that you've got them in a database, and employees can reasonably get a copy. And why do you want to do that? One, for the employee information, but two, let's assume we have an accident and an employee has got some type of chemical on them, and the EMTs are on the way there. The EMTs have no idea what that substance is, what the health effects are, and what they need to do. And if you can download that safety data sheet and hand it to the EMTs, they can start immediately giving proper medical treatment to the employee. So reasonably available means I can go to a kiosk, I can punch it in, and I can get it. So you don't have to do that, and you can, if you're out on a construction site, you don't have to carry a library of all the safety data sheets. As long as you have an iPad or an iPhone, you dial in, there's some national services, Chemtrek keeps them, you can buy a service, and they load all of your safety data sheets on so you can immediately access them.
So the second part of that question is, do we need to contact the fire department for their recommendation?
Okay, I'm not quite understanding the question. Depending on the industry you're in, you may have to file your safety data sheets with the local emergency responders. If you're subject to the EPA's risk management plan reg, you may have to file them. Otherwise, there's no obligation to do that. However, our recommendation is, since you have to have an emergency action plan to get people out of the workplace in the event of a fire or emergency, we recommend you invite the fire department in, you show them the type of chemicals that you have, you provide them with the safety data sheets so that when they show up, if they need to be putting on biohazard clothing so they can get into the plant and they can control the situation, they know what the hazards are. So is there an OSHA reg that says you have to give them to the fire department? No. You may be under an EPA reg to do so. Is it a best practice? Absolutely yes. Then they know what you're doing in there, and they can be effective when they come out to provide assistance to your employees.
We have someone that's asking for clarification on the post-accident drug testing. It's not allowed as a routine measure, question mark, only for probable cause.
Okay, there's a number of different forms of drug testing. One is pre-employment, okay? Another one is periodic, random, okay? Another one is for cause, okay? That's, in other words, you see conditions that would tell you that the employee may be impaired. Vapors, behavior, lack of coordination, things of that nature. As far as OSHA is concerned, and some people question whether they can even do this, and this reg may not survive. You need to be able to show, if you're going to do a post-accident drug screen, remember, not alcohol, only drugs, okay, that you have a reasonable belief that the employee was impaired. Now, in many cases, that is the same thing as the factors that you would use for reasonable cause. And we recommend that employers have a checklist for making the reasonable cause determination that it's signed by the supervisor and witnessed by another supervisor. And they have a checklist, eyes, of communication skills, et cetera, et cetera. It goes through all the different behaviors that you check off. You're pretty safe if you want to get around OSHA by using your checklist for reasonable cause, because that's going to get you to the same point that you had a reasonable belief that drugs were involved in causing the accident.
And I would also highly recommend that you provide reasonable suspicion training for supervisory personnel who are doing the incident evaluations and investigations.
Yeah, you want to, as Christina points out, you want it to stick. If you terminate somebody for your drug policy, you go to arbitration or you get some type of a EEOC charge, you want to win. That document is very important. If all of a sudden your supervisor says, well, gee, maybe it was the way he was talking. I don't remember that. Well, maybe it was the way he looked. Gee, I don't remember that either. Okay, then you're not going to have much, and you're probably going to lose that arbitration, or you're going to lose that case, and you're going to pay the employees some money, back pay, and in many cases, their attorney's fees.
So on the same lines, was the result of the Texas court case on post-accident drug testing ruling regarding OSHA's anti-retaliation?
The judge still hasn't ruled on that yet. Really? The lawsuit has been pending, and the judge has not, at this stage, the judge refused to enter a TRO, temporary restraining order, that would bar OSHA from enforcing that rule. It's still there, which to us is absolutely astounding.
That is surprising. I have a question on, can we put this training in writing and distribute it to our employees? I'm not exactly sure.
What do you mean? This, what I just did? This is that what you're talking about, training? This is this is public domain. I would think you would primarily want to share this with your supervisors, because the rank and file doesn't need to have all of this background information, and there's such a thing as TMI. We all know what TMI is. You're probably going to lose your audience. I would think I would filter down, if you're going to use some of this, I would filter down to the rank and file for what they really need, so that it's manageable information. This is intended for your senior management people, your frontline managers, so that they understand what the rules are and what the consequences are for not doing this, because they're a supervisor. When you're a supervisor, you're an agent of the company. So you have legal obligations far and above what you were when you walked in the door and started as an hourly employee. You have a different status now.
However, Mark does mention in his Leveling the Playing Field article that you are within your rights to prepare employees and let them know their rights for an OSHA inspection.
Yeah, the Leveling the Playing Field article is intended, in pages 8 and 9 are a crib sheet, and you can read that to your employees. And
you will get that. So, well, I don't see any additional questions that have come in. I do want to thank Mark for the excellent and informative presentation. I'm sure some of you are feeling a little bit overwhelmed right now. No worries, both Mark and Seyfarth Shaw and Corkill Insurance are here to help. So we will go ahead and conclude this webinar. The recording will be available. Thank you, everyone.
You got a good cross section here, Federal Mogul.